In the context of the nominating bodies, this isn't simply a question of identifying the social partners and automatically putting them in as nominating bodies. The nominating bodies have been carefully chosen based on their expertise in different areas and their areas of work. I'm not sure any particular added value would be brought to the expertise on the authority by just an extra two people, one of whom happens to be nominated by IBEC and one by the ICTU. Again, I'm not being critical of either of those organisations. They play a very, very important role. But I can't see what's going to be achieved, what's the extra added value by them nominating an extra two people and turning the body from being a body of 11 into 13.
Okay, well, I'll give you an explanation. If you look at that you're proposing to leave in the section in terms of the requisite skills, F, business and commercial matters, there is nobody in your nomination, no nominating body that has a particular remit in terms of business and commercial matters. So I think there is space to add IBEC in terms of that. And I think, in fairness, if you're adding IBEC, it is a due practice to have ICTU there also. So that's why I'm suggesting to widen out to 13 to include both of those bodies to deal with that particular identified area of expertise that you've put in, Minister.
Well, I just briefly replied to that. Amongst the nominating bodies that we're referring to here is the Competition Authority, the other body that we've referenced as a nominating body is the Consumer Association of Ireland. They all have insights into the areas the Deputy is referencing. Indeed, I would expect that some of those who may be nominated by the legal professions would have an insight into those areas. So in that context, I'm not convinced that we should add those two bodies. But I'll certainly say to the Deputy, because I'm anxious we have a proper engagement in this, that I will reflect on that between now and report stage. And perhaps the Deputies will also reflect on how large this body should be. I think it's important it doesn't become unwieldy. But I'm very happy to reflect on that between now and report stage.
And the chairperson issue, the issue of the chairperson?
Well, again, in the context of public confidence in the authority and in not being perceived as a body that is in any way dominated by the professions, I think there's an advantage in the chairman being a lay person. Indeed, the professions themselves have had lay people chairing certain committees on occasions for the same reason. And I think it is appropriate that the chairperson be a lay person, but if I'm interested in what the Deputy had to say about the members themselves electing who might be the chair. Now, there could be problems with that because I would have concerns that the body could start off in a divisive way, where there was, for example, and I'm not saying this would happen, but where, for example, all of the representatives of the legal profession wanted a particular individual as chairperson, but all the other lay persons other than that individual wanted someone else as a lay person. And it could sow the seeds for dissension from day one in the manner in which the authority operated. And in the context of the lay people being independently nominated, it was felt that an appointment of one of those as the chairperson is an appropriate way to go. So it there isn't a lobbying and pressure put on people who've only just met each other as the early members of the first members of the authority to determine who should chair. Indeed, that could be a matter of considerable difficulty at the start-up of the body. If you have a group of people who come together, they themselves may not be able to make a judgment as to who should be the appropriate person to chair. They may not know each other sufficiently well. So there are inherent difficulties in it being a sort of an election process. It would be different if these were people who had worked together for a long period of time, for example, on a committee, and after a year's working together, we're going to elect perhaps by secret ballot or otherwise, who their chairperson should be. So this was a way, one, of ensuring that no one can suggest that the government is any way interfering, because you have the nominees are independent of government, but that an appointment is made to avoid difficulty and dissension with regard to the day-to-day interaction between members of the authority or at meetings, because they start off with some God almighty row as to who should chair it. And I'm very anxious that doesn't happen.
Okay, Deputy McGrath.
Yeah, I was just going to come in there and raise a few issues with the Minister, but the fact that the Minister said there that he will reflect on the issue of the 11 or 13, and I just want to thank the Minister for that, because I think it's important that we have this broader expertise as well. I think personally I was going to make the point that 13 is a very sensible number, and I think it wouldn't be unyieldy as the Minister pointed out, but I think groups like IBEC and the ICTU would bring a new dimension to it and would have a different angle, but also a lot of years of experience.
Thank you. Deputy Collins.
Yeah, you see, the concerns that I have are probably the same as yours, but I'm coming at it from a different angle. If it's going to be a regulatory authority and the board of it to regulate the legal services industry, and it's breaking down 6-5, straight away the main legal players find themselves in a minority on the board. Am I right or wrong on that?
Well, you see, the legal professions are going to be regulated in the context of
I know that, yeah.
the work of the authority. I'm not sure what point.
Yeah, it's just, you know, you're breaking it down 6-5, okay? And one to the Bar Council, one to the Legal Aid Board, one to the King's Inns, and 2 to the Law Society. And then you have the 6 from the
other bodies.
Plus the chairperson then coming out of.
The 11 includes the chairperson.
Correct, but the chair comes out of the lay people, correct?
Yes.
Yeah.
Yes.
Could you not look at a composition? I know we're talking about 13 and you're talking about 11, which will at least give an equilibrium.
Well, what you effectively have, firstly, I think you need an uneven number. One would hope that when it comes to the approach taken.
Well, the chair will have, if there's a division, the chair has a casting.
I would hope when it comes to the approach taken on many issues that the members of this authority will sit and discuss those issues, and on most occasions will reach a consensus and will not have to go to a vote on something. But if they do go to a vote on something, it's important that the authority, frankly, isn't controlled by the legal profession. So that's why there's more lay people than there are members of the legal profession. And the chairman, of course, who would be a lay person, where if there was a division on an issue within the authority, and I hope this never happens, I hope that there will be dialogue within the authority. People may have different views on different issues, but I'd hope that issues wouldn't divide with the nominated members of the legal professions on one side of an argument and all the lay people on the other side of the argument. I would hope the internal workings would be quite different. But should there be a difference of opinion ultimately on an issue, it would be the chairman, if something had to go to a vote, who would have a vote on that issue quite clearly. And I think that's quite a normal structure to apply to bodies of this nature. I don't think there's anything unusual about that.
And are you open to considering what we're saying, to calibrate it, to recalibrate it? Are you sticking on 11?
No. What I said is I'm quite. I mean, I've listened to deputies. I'm quite willing to reflect on whether it should be 11 or 13. My concern initially, primarily, is that it doesn't become an unwieldy body, and I think that's very important. There is the issue as to the desirability or not of IBEC and ICTU having representatives on it. So I'm quite willing to reflect on that issue this side.
I think it's a fair point. It's a fair point to say that they should have equal representation around the board table rather than a minority.
Well, I think that could produce stasis. I think we're going to have to have an authority that has an uneven number. That would be the norm. There's nothing unusual
I know,
about that.
we'll have a chairperson.
Uh,
Yeah.
Well, as I said to the Deputy, I'm willing to reflect on whether the number should be 11 or 13, whether the social partners should be nominating bodies, and it would be interesting following this discussion also to see what reaction those interested in the bill may give to this particular suggestion. I'll simply reflect on that issue. I can't take it any further, Chairman.
Okay, I think we've given that a good run. So if I propose now to start taking the amendments and going through them here, we've discussed them together, 7 to 17. So we'll start with amendment number 7 in the name of Deputy McLaughlin. How stands that amendment?
I am willing to withdraw for now, but I reserve the right to resubmit the amendment later on the basis that the good minister will extend it to 13 and consider the matter.
Once it's discussed here in committee, you can obviously...
Yeah, no, fair enough. I'll withdraw for now. Yeah.
Amendment withdrawn. Amendment number 8 in the name of Deputy Collins and McGrath. How stands that amendment?
Sorry. Number 8, yeah. Look, I'll press the amendment. I know my Deputy McLaughlin's withdrawn. I'll just press it for the record.
You're pressing the amendment.
Yeah.
On amendment number 8, the question is that the new section be there inserted. Those in favour say tall. Tall. Those against say kneel. Kneel. I think the question is lost. Amendment lost. Amendment number 9 in the name of Deputy Collins, already discussed with 7. Deputy Collins, do you have chance to move?
Yeah, I'll press.
You're pressing the amendment. Amendment number 9. The question is, on amendment 9, the question is to be made. Those in favour say tall. Tall. Those against say kneel. Kneel. I think the question is lost. Amendment lost. Amendment number 10 in the name of the Minister, already discussed with 7 Minister to move.
I move.
The question is the amendment made. Is that agreed?
Agreed.
Agreed. Question, amendment number 11 in the name of the Minister. If 11 is agreed, 12 cannot be moved. So that's already discussed with 7 Minister to move.
I move.
The question is the amendment made. Is that agreed?
Agreed.
Amendment number 12 cannot be moved. Moved. Amendment number 13 in the name of the Minister. If 13 is agreed, 14, 15, 16, 17 cannot be moved. This is already discussed with 7 Minister to move.
I move.
The question is the amendment made. Is that agreed?
Agreed.
Agreed. Number 14 cannot be moved, 15 cannot be moved, 16 and 17 cannot be moved. On the section, that section 8 is amended, stand part of it. Is that agreed?
Agreed.
Agreed. Section 9, amendment number 18 in the name of the Minister. This is a new section, Minister to move.
I move Amendment 18, Chairman. Much of this proposed Amendment number 18 is of a technical nature in that it broadly reproduces existing provisions of the bill. For drafting reasons, existing subsections of Section 8 as published have been drawn into this new Section 9, for which the side note reads, Terms of Appointment of Members of Authority. Two aspects of the proposed Section 9 are significant in that they differ from the published bill. Firstly, it has been enhanced in that it includes a provision for the staggering of appointments. The staggering of appointments device echoes similar provisions in the Property Services Regulation Act 2011. It provides that at the inception of the authority, 5 of its new members will be selected by the drawing of lots to have only a 3-year renewable term. All other members will have a 4-year renewable term. The consequence of the provision is that there will still be a number of experienced members on the authority when the next group of new members are nominated. In this way, there is a graduated renewal of membership of the board and limited loss of memory and experience as members' terms expire. It will also prevent any wholesale reconfiguration of the membership by external actors. Second point to note is that the reference to the Minister for Justice and Equality determining the remuneration of members of the authority in the published bill will be removed if this amendment is accepted. It is but one example of my determination to reduce to the greatest possible extent the application of ministerial consents to the authority.
Okay. Deputy Collins?
Yeah. Can I ask, please, in relation to the appointment of members, and it was relevant to the previous section also, in terms of achieving gender balance on the board of the authority. If you get all male nominees or all female nominees, how do you propose to tackle that? or have you?
Yeah, that's provided for in the section, I think, which we've now passed, which deals with